rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. This is a time set for oral argument in Deanna Hawk versus Gary Hawk. Our case numbers CACV130764 and 140183 consolidated. Each side does have 20 minutes to present oral argument this morning. Appellant may reserve a portion of your time for rebuttal if you wish to do so. If you want to do that, please keep track of your own time at the clock on the podium. Out of respect for counsel, I would ask those in attendance to make sure that their phones are either off or on vibrate so counsel's presentations are not interrupted. We have read the briefs, we've conferenced the case, and we would encourage you to keep that in mind in your presentations today. Our proceedings are being recorded, so please, when you approach the podium, state your name and the party that you represent, and argument will be posted later on to YouTube as well. With that, let us hear, first from Ms. McCullough.
Good morning, Your Honor. Diana McCullough on behalf of the appellant, Deanna Hawk. I specifically asked for this oral argument because I wasn't sure if there was some confusion regarding the matter before you. The specific issues that I had, which are set forth in the briefs, are that the court lacked subject matter jurisdiction to award the grandparents' time. By that I mean there was no petition filed pursuant to ARS 25409, and therefore any Rule 69 agreement would not be binding upon the grandparents because the grandparents weren't a party to the action. Judge Porter had the choice of joining them to the action, making any orders that he had subsequently contemplated or made them a part of. If you'll notice in his October, both minute entries are October 10th, 2013. One was just later under advisement ruling. In his earlier one, he states that we're doing away with the grandparent visitation over the objection, or as a result of the objection of Ms. Hawk. But then later orders in that same minute entry later on, which was also filed on the same date, that the grandparents were restricted from drinking when they exercised their parenting time. So essentially, when the bottom line is, he awarded the grandparents, and father admits in his brief, they're his proxy. So I'm giving dad and grandparents dad's parenting time, and I'm giving mom her parenting time. But therefore ordered that from earlier on until the final, that they were given dad's parenting time. Simply by ordering that the grandparents couldn't drink on their parenting time or on dad's parenting time. So we think the court didn't have jurisdiction to do that. The grandparents were at liberty to file the 25409, which would have been subjected them to the scrutiny of the requirements of 409.
Counsel, let me ask you, as I read Mother's appeal, it is premised on the thought that the Superior Court awarded grandparents parenting time as opposed to allowing them to have access to their grandchild, to spend time with their grandchild, when father, in exercising his parenting time, couldn't. Have I misread the minute entries, or?
Well, right, except for it's not the typical babysitter or when I have my child.
And I understand that, but it seems to me if that's really what the Superior Court did, a lot of the arguments about jurisdiction or interpleading or joining grandparents as parties to allow them to petition for parenting time with their grandchild kind of goes away. And the issue then is, is it appropriate to place restrictions on someone who has contact with the child, recognizing parenting time? One way to look at the orders is that parenting time is awarded only to mother and only to father.
Well, right, and that would be the typical situation where you have a caretaker or you can't always be there for the child. Where somebody petitions the court, in this case, that's exactly what happened. Father petitioned the court, although the responding brief says that's not true, that's exactly what's in his petition. I can't exercise my parenting time. I can't have that, but I want more parenting time from you, court. I'm not gonna be able to exercise it. I'm talking to my boss about it, but right now, I'm out of state. I'm not even there. So instead of being with the other parent, he asks the court, give me more parenting time and let my parents exercise that parenting time, which is different than a parent that goes to work 9 to 5 and picks up their child. One parent can't have control over the other parent's parenting time, so to speak, but also can't subject to the child to somebody who's taking the place of a parent. It's far different, somebody that's taking my place and using the parenting time that the child could otherwise be with the other parent or an in-law or a grandparent.
And I understand what you're saying, but that seems a little different than how I read much of your briefing, that there was a jurisdictional defect because the grandparents hadn't moved to intervene or become parties and then seek their own parenting time. I didn't read this, Judge, and there's a little sloppy language, and I think you pointed that out. But I didn't read this record as the trial court awarding parenting time to grandparents as opposed to saying if father is in North Dakota or wherever and cannot, effectively parent for a short period of time, the child, that the grandparents could act in his stead. And to me, that's more, and I don't know what the analogy is because none of these are particularly apt, but with parenting time, the parent is not always with the child. I mean, school, preschool, babysitter, things like that. And this seemed more like a version of that as opposed to a jurisdictional problem. And that's what I'm trying to understand.
I think that it's actually both. I think it becomes a subject matter jurisdiction or jurisdictional problem because, one, there's no personal jurisdiction over the grandparents. So the final order that says you can't drink, there's no order effectively against the grandparents. So if the grandparents drink and have the child, there's no effect because...
Well, it would seem to me that that the trial court has some control over who can and properly should have access to the child. Do you agree?
Yes.
And if there were reports back that the grandparents weren't complying with the court's orders, sort of regardless of whether they had subjected themselves to the court's jurisdiction, couldn't the court amend those orders to account for that?
They could, but it would be too late, and they're not under the threat of contempt of court because...
But they're under the threat of no longer being able to be with their grandchild.
Well, yes, and that they're under anyway because they don't have grandparent time. It's almost as if it's a dichotomy.
Counsel, what authority is there to say that the judge can't do exactly what he did in this case, is to allow an accommodation for a parent that has to be gone sometimes to work, to allow a family member to assist with caretaking of the child? What is your best authority to say that can't happen or that violates subject matter jurisdiction rules?
Because a person that's going to stand in loco or be present instead of the parent, it's different than babysitter.
But where's the line? Is it 24 hours? Is it 48 hours?
Where you draw the line, I don't know that that's ever been defined.
I mean, you're not suggesting that a parent can't have a babysitter who's a relative, are you?
No, I'm not saying you can't have a daycare provider.
Yeah.
If it
I mean, it just
were
can be
that-
daycare. Can you have a night care provider if you need to, if you work at night?
Yes, and you can have babysitters 40 hours a week if that's what's necessary, and that's not really.
On each spouse's parenting time, they can decide what's best for the child.
On each parent's parenting time, that's absolutely correct. I don't disagree with that.
Well,
What I'm saying is this is going to step over that.
I mean, when you say, and I agree, you're saying it's going to step over, but how do we judge that it's going to step over? We have to have some kind of a line. We have to have maybe not a bright line, but some kind of a line where you could tell us the court has gone too far because why?
Because then every single parent I bring into court and I fight for parenting time, I'll say, they're not available for that parenting time. But you know what? They have friend Zoe who can be available for that parenting time. So court, can you please just order that my client's parenting time be awarded her, and if she can't make it, which I'm telling you she can't, Zoe's gonna do it. And Zoe's not under the scrutiny of anybody.
But the court's certainly not obligated to grant that request. And I don't know that you would be out of bounds by making that request, but the court certainly is going to take in the best interests of the child and evaluate that request carefully.
And if a petition for grandparents' rights would have been filed, the court would have then taken those into consideration. The court would have had it gone through the statute and make the findings and say Zoe or grandparents are suitable to
But-
stay in the
but-
place of.
But counsel, I mean, usually a petition for grandparents' rights is happening because the grandparents are being denied their ability to have a meaningful relationship with their grandchild. And so they want visitation, which, by the way, it's not parenting time anymore, it's visitation. And because of the change, the 2013 statutory change. So they're seeking that. So if they're receiving access to the child, why would they file a petition?
Because they weren't getting, what they wanted to do was replace father's parenting time, and that's what I think the difference is.
I mean, but not 100%.
Well, at the time, yes.
Well, at the time, but are we talking, but as that's, I thought that father rearranged his schedule so that he could now be in Arizona for the most part. Doesn't that record reflect that?
No, the record reflects that he was attempting to do so and planned on doing so in the future. But at the time of the ruling, he hadn't done that. That was not his testimony. He was working on it, was his testimony. So sometime in the future, I'll be able to exercise my parenting time, give me whatever parenting time I'm asking for, and allow my parents to take that parenting time. I think that's distinct from when I'm a competent parent, and whenever I have my child, I should be able to make daycare decisions. Aside from, in this case, at that time, mother had sole legal decision-making. So, and that was for a reason.
What about if we were talking about different situations with the grandparents, but so would it then be inappropriate for your client to allow the child to spend the night over at a friend's house because maybe the mother of her friend is like a second mother to her, and say that your client had to go out of town, and instead of calling the father, said, I'm going to let the child spend the night with, or spend the weekend with this friend. It seems to me that your client gets to make that decision. It would seem to me that your client gets to make that decision under this order, but you object to the father making the same kind of decision with regard to his parents. Would this friend of this child's mother have to come into court and ask for special visitation or special time with the child if your client had to go out of town for the weekend?
If my client had joint legal decision-making and made that decision over father's objection because father didn't know the competency, yes, then father would bring a petition and say, I object. She can't just drop this child off at this person's house. I don't know that they're competent. And she's doing it every weekend. That's her weekend. I think that that's where the distinction lies. When somebody who knows that they cannot exercise that parenting time and ask the court to award that parenting time so that they can take the child to somebody else. Or
So is it
somebody else.
your objection, or is it your client's objection that father is getting parenting time that he is not going to spend with the child, but instead the child is going to spend with the grandparents? Is that your client's objection?
That's been the objection, yes.
Okay, so, okay.
So
But doesn't
actually,
the-
just keep the
but-
parenting
but
time
count-
instead of grandparents having to file for
But counsel, doesn't that fly in the face of exactly what your client told the court? as part of the Rule 68 agreement, saying, I agree that the child needs to have a meaningful relationship with the grandparents. And I agree with, I mean, she stated on the record, she agreed with what the court had outlined.
Right, and it's my position that she could not have agreed because the court didn't have the jurisdiction to do what they had done to begin with.
Did you make that objection at the time of the Rule 69 agreement? That there was no subject matter jurisdiction for this?
No, and I was not the attorney of the record at that time. Any?
No.
Not this time, counsel. Thank you.
Thank you.
Ms. Hamilton.
Thank you, Your Honor. May it please the court, my name is Christina Hamilton, and I represent the County of Erie Hawk. And with all due respect to counsel and the court, I feel that this appeal is frivolous and unreasonable, and it needs to be sanctioned with an award of attorney's fees because there was a clear Rule 69 agreement specifically on this point, specifically put on the record by mom's counsel, and now we're arguing about it when that was the agreement. And I remind the court that mom's counsel specifically dictated the Rule 69 agreement as a specific designated time for the grandparents should be removed, that the grandparents should be allowed to visit on father's designated parenting time, and it is up to the court to determine what that will be following the hearing. And then the court restated that agreement and said, my understanding is the agreement that's been reached prior to trial in this case, the parties agree that with respect to the grandparent visitation, that any specific time set aside for the grandparents shall be, I guess, excluded from the order, and the grandparents shall see the children at the times designated, shall see Summer, the child's name, during father's parenting time. Is that the agreement? And then on pages 13 and 14, the court asked all of the requisite questions. Did you enter into this agreement voluntarily? Did anybody coerce you? Do you understand it? Do you think it's fair? And both of the parents said, yes, we agree to this. So the reality is it was a refusal to have grandparent visitation, a knockout of any such a claim, and the agreement that on dad's time, his parents could see the minor child. Period, the end. There was not a visitation issue where the grandparents were saying, hey, regardless of mom, regardless of dad, I want this designated time for myself with the grandchild. Now, what mom is really arguing about, but she doesn't say this in her pleadings, and so candidly I don't think she can not raise it on appeal, but nevertheless what she's really saying is, after the parties agreed to that, then mom proceeded to suggest that there should be a caretaker of choice provision added to the terms of the order, and that a parent should have the right of first refusal if the other parent was unable to care for the child. And after hearing from the court appointed advisor and the court hearing the testimony, Judge Porter said, I am not entering that order because that's just another area of contentions that these two parents who already have conflict will now fight about. And with good reasoning, because in the record, there were specific undisputed times when mom had refused to allow father to exercise his own time with the child. And in specific, there was one time where he said, I can't get there on Thursday night when my visitations are, I'll get there on Friday, is that okay? She said yes, and then refused to give him the remainder of his weekend visitation because she said he wasn't there on Thursday when the visitation started. So Judge Porter clearly heard mounds of testimony that demonstrated that there should not be a custody or a caretaker of choice provision or right of first refusal, and said so. And that's what mom's really arguing about, but you don't see that in her brief. And the reason you don't see that in her brief, I surmise, is because she knows that in an abuse of discretion standard, she would never win on it. That was Judge Porter's call to make after he heard the evidence. She can't win on that. So now she has devised this argument that really was never part of the panorama and clearly had been thrown out at the beginning of the trial in the Rule 69 agreement that this is all about grandparent visitation when it's not. And the court has hit the nail on the head in that what Judge Porter was really saying is, on your time, Dad, you can decide who's going to take care of the kids. On Mom's time, Mom can decide, and whether that's a grandparent, a friend named Zoe, a teacher, a caretaker, you make the call. And only because Mom had made these allegations without foundation that the grandparents had a drinking issue, then Judge Porter said, okay, well, I can clean that up by just saying, don't drink when you have a kid. Period, the end. Just like you could say to a caretaker, don't drink when you have a kid. I mean, it's just very simple, and Judge Porter was doing exactly what he had the authority to do, and which Mom gave the authority, certainly when she said, we're taking visitation off the table for the grandparents, that grandparents can see Summer during Dad's time. The other thing I would point out that the minute entry, again, acknowledges the Rule 69 agreement, and nobody said anything immediately after that, like, oh, Judge, you got it wrong. Never. The other things that I want to bring to the court's attention was that the issue of jurisdiction, which I'm not sure today what counsel is, whether she's saying there was no jurisdiction or not, but clearly the court, Judge Porter, has the right to do what's in the best interest of the child. And if that means putting safety precautions or identifying who can take care of the child, or saying, I'm not going to micromanage that, and you can decide on your own time, parent, there was certainly that jurisdiction, and that is all that he did. She identifies in her brief that Judge Porter didn't go through the statutory factors, but if you look at the minutes, he went through every single one of the statutory factors and laid out his reasonings for his rationales. And in part, he said that Mom's actions had been punitive. And the parenting coordinator in Exhibit 82 used the word punitive as to Mom's actions. So there were a lot of parts in here where Mom was not participating or doing things as the court was, that made the court concerned. And certainly the court had the ability not to grant the caretaker of choice provision. I've cited to the court the Higgins versus Guerin and the Guard versus Maricopa County cases, which say that when you enter into a Rule 69 or binding agreement, they're foreclosed from challenging that on appeal. So I really feel, again, that this is a frivolous appeal. There was certainly evidence both to support the caretaker of choice not being accepted, as well as moving from sole decision-making to joint decision-making, which counsel didn't bring up in her argument, but is in the brief, so I feel that I need to address that. And the court had an abundance of evidence that what was going on was not working. And it started in the divorce decree, where Judge Hilliard even said, I'm giving Mom legal decision-making, but I'm concerned that she won't get Father's input on decisions, and if she does that, then that might be a basis to change legal decision-making. And there was a clear record where Mom even admitted during the Judge Porter trial that, yeah, I never talked to him about the therapist. What do I have to talk to him about the therapist for? Even after the parenting coordinator had repeated and repeated in her reports, just because you have sole decision-making doesn't mean you don't need to talk to Father. There were times where Mother called the police to the exchanges, which were unfounded. There were incidents where Mother refused to give Father his access time, as I've already identified. There were at least three times there. And there were times when she refused to give the grandparents their visitation time. The court appointed advisor came in and said, I think that Dad's schedule change will be best for the child, which I just want to make sure everybody's clear. In a 14-day period, he already had 6 days of visitation, but it was broken up 2 nights in 1 week and 4 in another. All Dad asked was just consolidate my 6 days into one period. In that same 14 days, I'll still only have 6 nights. But if I have it all together, I can arrange my schedule from work and be there for those 6 days. And in fact, he has done that. And so for counsel to say he was asking for more time that he wasn't going to use, that's just untrue. The child was suffering significant anxiety from all of the conflict that she was experiencing, and the court advisor said she had not seen anxiety like this in a very, very, very long time. And the court was very concerned that reducing the conflict of interaction between the parents, as well as taking mom's unilateral decision-making away, would help to reduce the anxiety in the child. Mother was forewarned, as I said in the decree, that if she acted as she had been doing at the time of the decree, and then as was demonstrated at trial, that could cause her to lose her legal decision-making. She was also forewarned in the decree that it was very important for the child to have an open relationship and a very frequent relationship with both parents. And there was significant testimony where father had said, all right, look, my schedule is such right now, I can't be there on certain days that are technically mine under the schedule, but I can be here on other days. I'm here, can I come over and have dinner with her? Can I just drop a birthday gift off? Can I have an extra day? And mother repeatedly said no. And in court she said that I didn't have to, that was my time. So there was a constant abundance of that kind of evidence. There was evidence in the decree that the child had a wonderful relationship with both sets of grandparents, and that should be fostered. And at court, the court appointed advisor said that grandparents are fine. I've been out to their house, I've interviewed them, they're fine. I have no issues, Judge Porter, with the grandparents. The court also, in the decree, Judge Hilliard said, I would really think about giving these people joint legal decision-making, but to do that, I probably have to have a parenting coordinator involved, and right now, economically, I'm not sure they can afford that, so right now, I don't see that as an option. But if that happens, let me know. And since then, parenting coordinators were appointed, and in fact, Judge Porter, in a previous hearing, unilaterally or on his own motion, said, I want a stronger PC than what we already have. I'm putting Dr. David Weinstock in place. And so now the parties had a very strong PC to allow them to have a forum to make joint decisions with regard to the minor child. There's really nothing that I heard this morning that I think has much merit. There was no confusion. It was just a question of, on father's time, can he decide who's going to take care of the kids? On mom's time, can she decide who's going to take care of the child? And the only people that mom rose an issue about were the grandparents, even though she'd already previously agreed they could see the child on father's time. And then the court-appointed advisor said, well, I don't have any problem with the grandparents. So there was nothing that took this into the realm of grandparent visitation or took this out of the norm of somebody being able to decide how and who will care for the children on my parenting time if I have to work or do something where I can't be with the child. And the provision on putting in no drinking was just simply a precautionary bow, if you will, to mom's position that she was concerned about it, even though the court-appointed advisor wasn't, but just to have a safety measure in place. The only other thing that I just want to hit upon again where I started is the attorney's fees. This is a frivolous position. She agreed in court that father could have his time, that grandparent time was not even an issue to be addressed, and that the child could see the grandparents on my client's time. She was forewarned that her behaviors, she was forewarned in the decree that her behaviors could cause legal decision-making to change. She was forewarned in the decree that she needed to accommodate father to have open and frequent access with the child. The record was replete. She did not. And now today, for her to suggest that she wants to appeal the legal decision-making, when we didn't even hear about it when there was the first oral argument, demonstrates that's just a red herring that's been thrown in. And candidly, since it's an abuse of discretion standard and since the record is replete with information that would support the change, this appeal has been frivolous. So we request our attorney's fees and costs pursuant to the Civil Appellate Rules 25 and 25-324. And unless anybody has any questions, I don't really think I have anything else to add.
Thank you, counsel. Ms. McCulloch, rebuttal.
I think that there's some confusion here. That is exactly what Judge Porter ordered. He ordered grandparent visitation. He didn't say father can have whoever he wants watch the child on his time. He ordered the grandparents' grandparent visitation. In response to mother, filed a motion to clarify or correct the October 15, 2012 minute entry, which are the stipulations we're talking about here, in regards to the grandparents having court-ordered visitation. In response, the court issued its minute entry dated December 13, 2012, stating, and I quote, "It is ordered that on Thursday afternoon, when father would otherwise be exercising parenting time but is unable, the paternal grandparent shall be allowed to exercise grandparent visitation." It's
Counsel,
from noon until 7:30.
let me ask, I read the appeal as coming from the October 2013 minute entry, which modified the prior minute entries. Have I misread your appeal?
That's absolutely correct, where there is no Rule 69 agreement. It was a ruling. The Rule 69 agreements that we're talking about are throughout the case from 2000, I believe, 9 until 2012. As of 2012, Judge Porter had consistently ruled and put in his minute entries that based upon the parties' agreements, the grandparents would have grandparents' visitation. Mother kept moving and saying, "No, that isn't what I said. I said, I think they should have contact. That isn't what I said."
And I guess what I'm focusing on, and I believe Ms. Hamilton may have quoted it, was the colloquy in open court on the 10th of October 2013, reciting the judge's understanding of the settlement, or the Rule 69 agreement, and then both husband and wife, or mother and father, I should say, responded, I think, under oath that that was correct.
Right, and that was where they had agreed that there would be no grandparent visitation. But then under his under advisement ruling, he then says the grandparents can.
Right, and that's, I think, where the parties are in complete disagreement as to what the court did.
Right, the mother thinks or believes that the grandparents have grandparent visitation under all the old orders through the history of the case, that they can't drink during that period of time as a result of after the October 10th, but October 10th ruling by Judge Porter. I didn't raise the issue earlier regarding the sole legal decision-making because I thought that the briefs briefed it well. I think there was an overwhelming amount of evidence regarding these parents' inability to have joint legal decision-making. That was affirmed by Lisa Duff, the court appointed. And so mother's quandary at this time is, I have an order that's simply not clear. And we filed a motion for reconsideration. Judge Porter, please change it. Our agreement is that grandparents aren't ordered any grandparent visitation. Please clarify that. We asked for that in the motion for reconsideration, and it was summarily denied. So
And
mother had
if-
no relief.
If this court were to view the order instead as allocating parenting time between father and mother, but specifying who can have contact with the child during father's time, that issue would go away. Is that fair?
Yes, as long as it also does not specify that that grandparents wouldn't be drinking during their parenting time.
Well,
Or during any visitation.
is your client objecting to that provision?
She doesn't object to that provision, except to the extent that it seems to insinuate that the parties didn't agree that it was to be no grandparent visitation. And I think something along the lines of many of our decrees or orders that say neither parent or anybody the parents leave the children with should be drinking at the time they're watching the children. I think the specificity of the grandparents, and Judge Porter may have intended it to be for her benefit, but the specificity of the grandparents, when so many times he had ordered grandparent visitation, was a concern of mothers.
Thank you, counsel.
Thank you.
Counsel, we appreciate your briefs and your argument today. We will take the matter under advisement. We'll issue a ruling in due course. Thank you both. We stand adjourned.